everybody. Douglas V. Gibbs here, Mr. Constitution. And let's talk about the recent case regarding the gun permits that the Supreme Court has heard. The case is the New York State Rifle and Pistol Association versus Bruin. And for a lot of people, this is a major win, but it poses a lot of interesting issues, to say the least. Thanks to the current regime that's in place, guns is a big deal. We've had these shootings lately, and everybody has decided that, well, guns are dangerous, and you shouldn't have them. Well, not everybody. But, we have this enemy of the Constitution who is doing everything they can to, well, I think eventually confiscate firearms. But the Second Amendment is clear. The Second Amendment reads that a well-regulated militia being necessary to the security of a free state, the right to keep and bear arms shall not be infringed. That's not all the words. I did it from memory, but we'll get into the language in a minute. But basically, when it comes to Second Amendment, what it's saying is you have the right to keep and bear arms. The word keep, to possess, to own. Bear is to, if you go look up the 1828 Webster's Dictionary, in that dictionary, the third definition down gives an example of keeping a gun under one's coat. So the word bear then would be to conceal carry. You have that right. So why do we even need permits in the first place? Now, we have a bunch of states, I think it's 25 or more right now, they have concealed carry, constitutional carry, should I say, laws where you don't need a permit. You can carry, period. About half the states in this country. But then you have 6 states that have not only requirements in order to get your concealed carry permit, but that you must prove that you need it. The exact words that they use is good cause or proper cause. And so basically what it's saying is that you have to convince the government that your personal safety is at risk, more so than the general population, and so you have special reason to carry a firearm in public. And so these 6 states have had these laws, and in New York, there was a couple of people said, no, we're denied because we don't have just cause or good cause. No, our good cause is the fact that we want to be able to protect ourselves, and we feel in danger. We have the right to keep and bear arms. And so this case worked its way up to the Supreme Court, where they heard the case, and basically what they decided was, no, you can't go that route. Everybody has the authority, the right, the God-given right to protect themselves in public, and so these 6 states can't have this extra good clause. Being a citizen is good enough reason. Now, this is the first case regarding the Second Amendment since Heller in 2008, and the McDonald v. Chicago case in 2010. And McDonald v. Chicago, I bring it up often in my videos and in my classes and my speeches, because what happened in McDonald v. Chicago is very important. What happened was that the city had banned handguns, and the United States Supreme Court said they couldn't do that a city couldn't ban handguns. And so everybody got a hold of me saying, hey, it's a win for gun rights, Doug, because, the Supreme Court said that Chicago can't ban handguns. And I said, well, don't be so sure about that. We just had a federal court dictate to a city what it could or could not do regarding gun rights. Do you really want that government involved? Now, remember, when it comes to the Second Amendment, now I'm going to go over the language because I really want you to understand this stuff. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. A well-regulated militia. Who is the militia? According to George Mason, the militia is the whole of the people and a few politicians. Public officers, I think, is the word that he used. Being necessary. It's not just a suggestion. It's necessary. It's like the word shall. It's mandatory. It's necessary. Necessary to the security of a free state, a free California, a free New York, a free Massachusetts, a free state. Necessary to the security of a free state from whom? The deer, if they rise up? No. A foreign invader? No, that's what the military forces are for. What's for tyranny? It's necessary for the security of a free state against a tyrannical federal government. I mean, the Founding Fathers, they kind of were going from experience here, right? Lexington and Concord. What was Lexington and Concord all about? The British were coming to take the guns. And so what the the Founding Fathers, the revolutionaries do at the time? They confronted them. They used their firearms to stand firm against them, said, hey, You can't take our ammo. You can't take our guns. We're gonna, and they delayed them at Lexington, so like up in Concord, they moved the stuff. But did you notice that when it comes to your history of the American Revolution, the final straw was our guns, and when they came for our guns, that's when we were like, whoa, wait a second, going too far here. And so the thing is, and then it says the right of the people. So this idea. Well, it's got to be a militia. If you're not a member of the militia, you don't have a right to keep and bear arms. The leftists are liking to say that. Then what does right of the people mean? Right of the people. It is a right. And when we say right, what we mean is it's a natural right given to you by God. It's a gift from God. You have a gift to keep and bear arms. And so you have the right to keep, own, possess, bear, conceal, carry arms. So, well, Doug, my arm, that's just a musket. Because they didn't see an AR-15 coming. Well, it's funny. If you look up the word arms in the dictionary, guess what? It doesn't say musket. In fact, it doesn't even just say guns. An arm is any kind of weapon. In fact, our idea of keeping and bearing arms comes from the Saxons because they carried a blade called a sax on their hip, and that was their keeping and bearing arms. If they were arrested and punished, then their sax was taken from their possession, and then when they were released back into their realm of liberty, they were given back their sax. That sax was their symbol of their liberty. Keep and bear arms, a blade, a knife. Arms is more than just a musket. It is anything that is necessary to defend yourself, not only against an oncoming bear or a criminal or whatever else, but also, yes, a tyrannical government. And the whole point of it is for us to, it's like, I remember watching a video years ago. There's this woman talking to this like city council, and she says, hey, we have the Second Amendment so we can protect ourselves from you. And she was right. All right, so to the right to people to keep and bear arms shall not be infringed. Shall not be infringed means in any way whatsoever. Now, when I say what I'm getting ready to say, I want you to hang on to your seats because some of you, for a moment, will be negatively influenced, but I want you to hear me out and let me fully explain. When the Second Amendment was written, it only applied to the federal government. If it applied to the states also, the states wouldn't have needed to put gun language in their state constitutions. Yet 49 of the 50 states all have gun language in their state constitutions. Why would they have gun language in their state constitutions if the Second Amendment applied to them? It doesn't. Now, I'm not saying the states can just hop all over your gun rights. That's not what I'm saying. I'm saying that the language here applied to the federal government. So shall not be infringed. That's pretty definitive. And so if it only applies to the federal government, here's what it means. Every single federal gun law and federal involvement in guns is unconstitutional. That means no background checks, no assault weapon ban, none of that. So, Doug, you don't think people should have a background check? I didn't say that. If a state wants to have that law, they can. The states are allowed to make laws regarding their guns from the founders' point of view. But they're only supposed to make with it what is believed by the populace, by us, because we're closer to that government. They're supposed to listen to us. What is necessary, and in this case here, the Supreme Court's saying, hey, it's not necessary. You're going too far. You're going beyond necessary. You 6 states that have this good cause, proper cause clause in your permit process. So therefore, we're telling you can't do it. Now, I disagree with the federal courts policing the states on this, because once again, they don't really have that authority. But at least they came to the right decision when they do act outside the Constitution in the sense of going dealing with the Second Amendment. Now, that all said, well then, Doug, are you saying that they should be able to have permit laws? Well, not necessarily. The right to keep and bear arms isn't your right because it's in the Second Amendment. It's your right because God gave it to you. So, Second Amendment or not, piece of paper or not, we have a right to keep and bear arms. Therefore, constitutional carry laws should be the law of the land. First of all. Second of all, even if there was permits issued, the fact that there are states like California that will not recognize permits to conceal carry from other states, well, that's unconstitutional. Because what does it say in Article 4? Article 4 basically gives reciprocity. In other words, full faith and credit. Full faith and credit meaning if you have a permit from one state and you go to another state and you got your gun on you, that permit's good. It has to be accepted by the other state as valid. It's like your driver's license. You don't have to stop in the next state over to get a new license because your license is no good. Reciprocity, full faith and credit. That license works no matter what state. Well, then why isn't your gun permit the same way? Of course, when we get back to why should we even need gun permits? I personally, I think the sheriffs of this country, then states that don't have constitutional carry laws, should just say, hey, we have a constitutional carry county. They can do that. So you have the Second Amendment that is in place to protect us from the government, and we have the Supreme Court saying, hey, we are saying you've gone too far, New York and California and those other states. Now, the Chief Justice that really had the opinion that caught everybody's attention and always does, well, Samuel Alito too, but was Clarence Thomas. Clarence Thomas has been under a lot of fire. The left can't stand him because there's something wrong with him. He's conservative-minded. I hate the word conservative. We're not trying to conserve the Constitution anymore. Now we're trying to restore it. That's beside the point. But he's not in their camp, and he's black, and they can't figure that out. How is that possible? Well, you're black, you must vote Democrat. Biden said so, right? Anyway, so Clarence Thomas, when he had his opinion over this particular case, what he basically said in his opinion was, he said that the law in New York violates the Constitution by preventing law-abiding citizens from defending themselves in public. What was even more interesting to me is a 6-3 vote. Roberts sided with them. He had been, John Roberts, I think, has been kind of a turncoat. I've always wondered, well, what might they have on him that's got him acting the way he's been acting in some of his votes? But nonetheless, he joined the rest of those particular justices. So the three you would expect, Breyer, Kagan, and Sotomayor, were against this, but the rest of them agreed. And Thomas wrote, to confine the right to bear arms to the home would nullify half of the Second Amendment's operative protections. Moreover, confining the right to bear arms to the home would make little sense given that self-defense is the central component of the Second Amendment right itself. After all, the Second Amendment guarantees an individual to possess and carry weapons in case of confrontation, and confrontation can surely take place outside the home. Many Americans hazard greater danger outside the home than in it. Now, I love the way they said this, confrontation. He's making it sound like we're talking about confrontation with bad guys. It's confrontation with the government trying to take our liberty. That's what it's really about. And I think that Clarence Thomas and Samuel Alito truly believe that, but they stopped short from actually saying that in their opinions. And when it came to Alito, Samuel Alito's words, that I have ready for you here, is that he suggested that the residents in these 6 good cause states will finally be able to defend themselves more meaningfully in public when the government cannot, which is sadly most of the time. So once again, they're saying, oh, well, so you can defend yourself when the government can't defend you. Once again, they're dancing around what the Second Amendment's really all about. This isn't about defending or whatever, me defending myself against, if the deer rise up. No, this is defending myself against the government, and they're stopping short from saying that. Now, we have to remember that the United States Supreme Court is a part of the federal government. And, I'm not a fan of, and I believe it's unconstitutional, actually, for the court to strike down state laws. So once again, they did the right thing, kind of the wrong thing. It was once again, if you read the preamble to the Bill of Rights, the purpose of the Bill of Rights was to prevent misconstruction or abuse of its powers, it being the federal government. The states weren't, when they created the Bill of Rights, the states are the ones that wrote it. The representative states in the legislature, proposed it, and state legislatures or conventions at the states ratified it. It wasn't because they were worried about themselves. They wanted to protect themselves from a tyrannical central federal government. So once again, I'm not a fan of the federal government even poking its nose into gun rights. But like I said, while they came to the right conclusion, didn't really have the authority, but we're going to go with it. I mean, nothing I can do about it. I can say, hey, you got to let the people turn New York around. That's really what's supposed to happen. But, well, we've fallen down on the job as the people, haven't we? So anyway, so that's the so that's our New York versus what is it? New York State Rifle and Pistol Association versus Bruin. And that's what we got going here. And for the first time in very long time, Second Amendment has been applied here when it comes to a Supreme Court case. But here's the thing, and this is maybe hopeful thinking. I think this sets up another challenge. I think this sets up gun permit laws being required in states being challenged at all. I think that's going to happen. I think what's going to happen is there's going to be a lawsuit that says, hey, constitutional carry should be the law of the land. If I have the right to keep and bear arms, why do I have to get a permit? And I believe that's the next case we're going to see. I have a feeling this isn't over yet when it comes to Second Amendment. I have a feeling what we're getting ready to see is the United States Supreme Court literally say to states, you can't have gun permit restrictions at all, which means we'll see plenty of guns probably in the hands of good guys, which means the number of shootings goes down. I'm a firm believer that the best way to stop a bad guy with a gun is a good guy with a gun. And as for you people out there wondering, oh, well, Doug, don't you think guns are dangerous? We need to at least have some type of control. Well, if you were to, let's say, hypothetically, lefties, get your way and confiscate all guns, just every law-abiding citizen doesn't have guns anymore. You do realize that would do two things. That would leave resourceful criminals with guns while the law-abiding citizens don't have guns. And that would leave the government with guns and the law-abiding citizens without guns. So my first question to those of you who want guns confiscated and taken away from people, are you happy with the government being the only ones with the guns? If Trump was elected again and was president and both houses were Republican and government were the only ones with guns, would you be happy with that? Careful what you wish for. You might you might put yourself in a situation where you have no way to defend yourself against the government that you hate. Of course, I don't think that particular government would be a problem in that sense, but I do want the lefties to think about it. All right, thanks for watching this video. I'm going to try to get more out real soon. United we stand, combined we kick butt. God bless America, and my friends, God bless you. I am Douglas V. Gibbs, Mr. Constitution, douglasvgibbs.com, and politicalpistachio.com. Political Pistachio is my blog. douglasvgibbs.com is a website where you learn a little bit about me. I have donation pages at both websites, so if you want to help fund what I do, because matter of fact, this particular video in late June, I'm like a week away from going out to Denver to speak at an event out there, and I haven't even collected enough funds to even carry out that event yet, to even get there. So if you want to help out, I'm trying to get around the country. I'm trying to get the word out, do what I need to do, because we've got to restore our Constitution. We need to restore our republic. We need to get this thing back, and I think it can be done. But we've got to do it. We can't just sit on our laurels and wait for the Supreme Court to save us. Because, well, they may have gotten a couple of rulings right lately, but quickly things can turn. We learned that, didn't we, with this latest presidency? All right, thanks for watching. We'll see you next time.